The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen, and welcome to this IT governance webinar on how to conduct effective data protection impact assessments to minimize your privacy risks and to maintain your GDPR compliance. I'm Alan Calder. I'm the founder and executive chairman of IT Governance. I'm going to be your host this afternoon. The webinar overall will be around about 45 minutes, 50 minutes of me talking. You'll notice that you're all on mute. That's to make sure we don't get background noise and similar kinds of interference. There should then be, at the end of the webinar, around about 5 or 10 minutes worth of time when you can ask and I'll answer any questions that you've got. The way to ask questions is to use the questions box in the GoToWebinar panel, which should be on the right-hand side of your screen or wherever you've got it on the screen. If you open that box and you can click in there, you can type in any questions that you've got. When we come to the Q&A session, what I'll do is I will read out the questions, provide an answer, and I'll try and get through as many of those as I can in the time that's remaining. IT Governance, as you probably know, is a leading global provider of IT governance, risk management, and compliance solutions. And since about April 2016, GDPR has been a major part of our service offering. We kicked off that service offering with a pocket guide on GDPR. I've been writing books around cybersecurity and IT governance for many years, and IT governance as a business has grown quite substantially. We focus on the broad range of governance, risk management, and compliance, but particularly around cyber resilience, data protection, cybersecurity, PCI, ISO 27001 penetration testing, a veritable one-stop shop of everything that organizations might need to access in order to take forward their complex range of privacy and security requirements. The webinar today is going to be looking at the legal requirements for DPIA. We're going to be looking at the benefits of conducting DPIAs within the organization over and above simply what the GDPR compliance obligations are, how to embed DPIAs in your risk management framework, which is essentially what the General Data Protection Regulation is looking for, and then the practical steps to conducting a DPIA and linking it back to the six data protection principles set out in the GDPR. As I'm sure you're all aware, the GDPR applied from the 25th of May 2018. Many have noticed the big spike in activity as people try to do a minimum or something that might look like compliance by the 25th of May. That was the end of the transition period, and we're now in the period where mostly organizations are just hurrying to try and get enough done to make sure that when the inevitable happens, a data breach or a data subject access requirement or complaint, that you're going to be in a position to deal effectively within it in a way that doesn't bring down the wrath of the information commissioner or indeed of distressed and upset customers. The regulation extends the data rights of individuals. It says that all organizations have to have in place clear policies and procedures to protect personal data with appropriate technical and organizational measures. And the definition of appropriate technical, organizational, and measure is absent from GDPR, so the determination of what those are is going to be a combination of practice and court actions. We think, and we've for over 2 years now taken the view that what's appropriate is whatever is going to reduce the risk to the rights and freedoms of data subjects to a level that is going to be acceptable to them. And the way to avoid fines and to avoid reputation damage is to make sure that you've done everything that is reasonable and practical, not only from your perspective, but also from the perspective of the data subject, to bring the level of exposure that they have down to a level, down to something which would be acceptable to them. A couple of definitions that are in GDPR and therefore important to anybody working out whether a DPIA is necessary or not. The first is who is within scope for GDPR. GDPR applies very specifically to the protection of personal data belonging to natural persons. A natural person is a living human being. Animals don't have rights, artificial intelligences don't have rights, companies don't have rights under the GDPR. And that means, for instance, that an email address, which is a person's name, Alan Calder at itgovernance.co.uk, that's personal data because it identifies me, but an email address which is for the company alone, like info@itgovernance.co.uk, has no rights at all because it doesn't identify a natural person. So natural persons have rights to the protection of their data, to the protection of how that data is processed, and to the protection of the systems within which the data is processed. They also have rights, relatively speaking, to the unrestricted movement of data within the European Union. And these requirements, these rights apply to controllers and processors. And a controller is the organization that determines the means and purposes of processing, irrespective of whether that controller is in the European Union or outside of it, where services are being provided into the European Union. Same thing applies to a processor outside the European Union. If it's providing services into the European Union, then it has to comply with GDPR. Within scope is any personal data that's processed wholly or partly by automated means, and any personal data that's part of a filing system or is intended to be. Filing systems, of course, obviously include paper data and any other form of traditional methods of holding and processing data. Automated means is any information technology or similar system or any automated method of processing. So wherever you are in the world, if you're providing services in the European Union, you have to comply with GDPR. You have to do it in respect to all personal data, and you have to do it in respect of all personal data, whether it's paper form or in digital form. And if you don't, at a generic level, there are, again, as you'll know, significant fines up to a maximum of 2% of global turnover or 10 million euros for a tariff of lower level offenses. Lower level offenses include failing to report a data breach, failing to have proper records of how you're processing data, and up to 4% of turnover for the significant breaches. Those are failure to properly protect the rights of data subjects, a failure to comply with the 6 data processing principles, and failures in respect of international transfers of data. The fines have to take into account, they have to be effective, proportional, and dissuasive, but they have to take into account the organizational and administrative measures that you put in place, and they have to take account of the level of negligence displayed by the organization. So one way, if you accept that the likelihood is that as an organization you're going to be breached, one way of minimizing the size of fines that you might be facing is to do everything that is realistic and sensible to minimize the impact on data subjects if there is a data breach. Being able to demonstrate that you've done whatever you could do is mitigating and will be able to be taken into account to reduce the size of any potential fine that's levied against you. So, very important part of your compliance strategy, what can we do to demonstrate to provide an auditable track record that we've taken appropriate steps to put in place appropriate technical and organizational measures to protect the data of natural persons whose data is being processed in automated or online or cabinet or paper cabinet filing systems. At the heart of how you do that is what's called a data protection impact assessment, and the key requirements around DPIAs are contained in Article 35 of GDPR. What Article 35 basically says is that a DPIA should be used to help identify and address risks at an early stage in analyzing how the proposed uses of technology and of personal information will work in actual practice to put in place methods of mitigating risk. So at an early stage means if you have, for instance, a plan for a new IT project, you're going to roll out a new accounting system, or you're going to merge 2 customer related CRM databases, for instance, before you start on the exercise, you need to do a DPIA. And you need to do one because you're going to be changing how you're processing personal data, and therefore you need to work out what the sensible steps are to mitigate new risks which might occur to the data subjects in that circumstance. So a DPIA is a process. It's a process to identify and reduce privacy risks in a project or a system. A process can obviously use a tool. It doesn't have to. A process can be carried out by people simply working together, and that can be an expensive and complex process, whereas using a tool can simplify, systemize, and standardize what you're doing. An effective DPI should be initiated at the start of a major project, sometimes the start of minor projects, and should be maintained throughout the project. In other words, as the project is going on, this is particularly true of agile development projects, where at the beginning of the project you don't necessarily know how things will look towards the end of it, but you do know what the initial set of risks might be. A DPIA might have to become part of the Scrum process, where one or more people inside the Scrum own initiating and then maintaining the DPIA throughout the period of the epic that you have in place. So DPIAs should, particularly if they're being updated, but what they're essentially doing is trying to make sure that the risks to the rights and freedoms of data subjects are identified and mitigated or minimized. Ideally, you want to get to the point where there are no risks, certainly no risks that you might want to tell the data subjects about. DPIAs, before you even think about the mitigation of negligence accusations that might come in the case of breach, data protection impact assessments are good business practice anyway. And I'm going to start off looking in some detail at DPIAs by looking at the business benefits of a DPIA. It's not just a compliance exercise. It's certainly, for instance, a method of being transparent with data subjects and setting out clearly what you intend to do with their data and how you're going to protect it. Most people have had the experience of trying to purchase something from or download something from a website where it's not clear what they're going to do with your data. It's not at all transparent how they're going to handle it, and you have significant concerns as to whether or not that data might be compromised at some point. So excuse the thing. So the two principles of GDPR, which this is going to help you deal with. The first principle, which is that data must be processed lawfully and fairly. And the second principle, which is that the amount of data that you collected must be limited to the purpose that you set out to collect the data for. So first two principles met by DPIA, and the business benefit of being transparent with data subjects as to what you're doing and why you're doing it. You can also build trust with the DPIA by publishing certainly an overview of your DPIA process, of the key decisions you've made about how you're going to protect data. You can help the data subjects get a proper understanding of what you're doing with their data, and therefore have a level of trust in how you're handling their data, such that they're happier and more capable, more able to share with you the type of data that you want with them. Publishing a DPIA is obviously more useful if you're doing more sensitive things with data or working with more sensitive data. It's certainly useful if you're working with big data and you're likely to be using the data of data subjects for things which they might not even initially expect that the data will be used for. It's particularly useful to be clear with data subjects what you're doing with their data in terms of securing their data. And by this, I don't mean publishing the sort of information that would enable a hacker to determine the best way of getting at the data, but telling data subjects the type of measures you put in place to protect data. So you might say, for instance, that your data is held in an encrypted database where we email it. It's sent only over email systems that are encrypted. It's accessible only by those who are specifically authorized to access your data for the purposes for which you've given it to us. And we're audited on this basis on an annual turnaround, so you can have some confidence that we're doing what we say we're doing. Is a way in which, for instance, you might demonstrate the level of trust a person might have, an individual might have in how you process their data. There's also the financial benefit that you reduce the costs of processing and storing data. If you're only collecting the amount of data that you need for the specific purpose that you've collected the data, and you restrict the amount of data and the period of time you hold it to the purpose for which you collected it, you can, over time, particularly in large organizations, reduce the amount of data you hold. You also reduce the amount of work and effort that you might have to put into handling a data subject access request, to examining the extent to which data has been compromised in a data breach. Because you're holding as little data as possible, all of those costs and time and effort will enable you to take a more sensible approach to bringing those costs down. So the benefits of a DPIA then to an organization, broadly speaking, are that they improve awareness internally, they improve compliance, and they improve the level of assurance which managers and third parties, customers and suppliers can get about how the data is being managed. So internally, carrying out a DPIA involving all the people who are processing data in a particular process will help them understand what they have to do to ensure that data is managed in a way that complies with the regulation. And that awareness will translate into better compliance. Not only will staff be aware, but they will be making sure that the process works as it's meant to work. They won't be looking for workarounds because they will have made sure the process is designed adequately to meet their business requirements while also achieving compliance requirements. And you'll be able to give assurance to not only the people whose data you're processing, but also to the business as a whole, to customers and suppliers, that you are acting in compliance with GDPR, and the dangers of a data breach therefore are substantially lower. So a number of business benefits, and as you've seen, we've begun talking about the legal requirements of a DPIA as well. So let me just more formally pick up those requirements, which are set out in Article 35. And Article 35 says that a DPIA is required where an organization in particular is using new technologies, taking account of the nature, scope, context, and purposes of the processing, but where those new technologies likely result in a high risk to the rights and freedoms of natural persons. Not a risk, a high risk. It's also specifically required in cases where you are doing automated processing, including profiling, where decisions are based on the profiling. For instance, automated profiling which makes decisions about whether you should be offered a mortgage or not. That would be a processing which falls very clearly into that first set of requirements. If you're running that type of an operation, if you are determining whether or not people will be allowed to apply for a job on the basis of automated processing, there are consequences, legal effects for the data subject, so you will need to do a DPIA. The second area where a DPIA is mandated is large-scale processing of special categories of data or of personal data relating to criminal convictions. Note this is large-scale processing of special categories of data. So you might be processing millions of names and addresses, but those aren't special categories of data, and therefore you don't, by law, need to do a DPIA. It might be a good idea to do from a business point of view, from a trust with data subjects point of view, but it's not a legal necessity. Special categories of data, you'll recall, are things like health, political opinion, beliefs, gender, health. All of those are special categories of data. If, as core to your business, you are processing large quantities of that type of data, then a DPIA is mandated. You must do a DPIA. GDPR, while it talks about if you're building a new system, you must do a DPIA, it does not say that you don't need to do a DPIA if you're processing the data prior to the 25th of May. So the legal assumption is that any data you're processing that meets the requirements of any of these three areas that you were doing prior to the 25th of May, you also need to have done, and if you haven't, to do as quickly as possible, a DPIA to make sure that the ways in which you are processing that data is going to be compliant with the GDPR and is going to be protecting the rights and freedoms of natural subjects. The third requirement is the systematic monitoring of a publicly accessible area on a large scale, and that means, for instance, CCTV. You're monitoring lots of people, not maybe on a single back garden, but if you're monitoring large numbers of people in the public area, like in a square, or people coming in and out of a building, those are all potentially going to get caught by this third category. There is a fourth category. While these apply to all organizations, public authorities are also required to do a DPIA. So you might think, for instance, what would apply to a constituency officer for a member of parliament. Members of parliament are, broadly speaking, processing large quantities of special categories of data. They're dealing with political beliefs. They may, in terms of looking after constituency members, be dealing with health, social security, political belief, religious belief, a whole number of special categories of data. It's core to their activity, and so a DPO is necessary. GDPR doesn't say DPOs, so clearly a DPIA is necessary. It doesn't say DPIAs only have to be carried out by large organizations. DPIAs are applied in circumstances where organizations are doing certain types of activity. So, Article 35, the controller has to seek the advice of the data protection officer. If you are likely to have to carry out by law a DPIA, you're also likely by law to have a DPO. The categories for what organizations require a DPO mostly overlap, and the supervisory authorities are over time expected to publish and keep up to date a list of the specific types of process for which a DPIA is necessary. That's not necessarily going to be an exclusive process. There may be other processes that fall outside of it. So legal requirements for DPIA are fairly broad, and in most organizations there are probably between 2 and 5 processes that are likely to be captured by the requirement to carry out a DPIA. What a DPIA has to set out, the document that you produce at the end of the DPIA, by law, has to describe systematically the processing you're doing and why you're doing it, the purposes of the processing, what legitimate interests you're pursuing in the processing, the necessity and proportionality of the processes. It's asking you to make sure that you are actually complying with the requirements of the 6 data processing principles. You have to assess risks to the rights and freedoms of data subjects. And again, you need to be doing this on a systematic and structured basis. You can't just go, nah, that doesn't matter, we'll ignore that. It has to be something that you're going to be able to demonstrate, if necessary in a court, was an appropriate mechanism for assessing risks. The measures that you put in place to address risks could include codes of conduct where they're available, complying with appropriate national and international standards where they exist, and putting in place any other demonstrably obvious security measures and safeguards to protect data. So encryption is an obvious security safeguard to put in most instances, because that reduces the level of risk to a very low level. GDPR also says, where appropriate, consult data subjects. And if you think about it, one of the purposes of the DPIA is to give data subjects some sense of certainty that their data is being processed properly. So consulting them in a structured format, not necessarily by the 1,000, but certainly perhaps representatives or through some form of survey. Those are sensible mechanisms for consulting data subjects. When we talk about risk and establishing what the risk is to data subjects, you have to have some definitions around risk. You have to have a method of determining what risk is. It's really not intended to be, nor should it be, something which is subjective. ISO 31000 is an international standard to which many organizations turn in looking for data about risk and risk management. And ISO 31000 defines risk as being the effect of uncertainty on objectives. Risk is the stuff you've got no idea how it's going to work, but it's going to get in the way of achieving the objectives you set. In more practical terms, risk is a combination of the likelihood of something bad happening and the impact on the organization if it does happen. So obviously the likelihood of a tornado in the middle of East Anglia's Fens is low. The impact, if it were to occur, would be high. As a risk, you're probably going to determine that it's low on account of the likelihood being low. So you won't take big preparations to deal with it. The same logic applies to looking at risks to the rights and freedoms of natural persons. And you're looking at the extent to which damage to the systems, injury to individuals, loss of data, any other negative occurrence that might occur, external attack, internal failure of systems might lead to a compromise of the confidentiality, integrity, or availability of the personal data that you've collected. So you need a systematic method for determining what that might be. And you've got to think about risk in two contexts. You've got risk to the organization and you've got risks to individuals. And those can be different. An organization might say, we're very happy to take quite a high risk that our database will be compromised because actually we've got lots and lots of copies of it, so we don't really care if somebody steals it, and it didn't cost us very much anyway. Whereas all the individuals on that database might think that a compromise of their data is being stolen and being sold on the dark web for 20 pence per 100 is exactly what they don't want to happen to have their data. So organizational risk appetite in respect of impacts on the organization will often be different than what the assessment of risk should be in relation to the impact on individuals. Both types of risks to individuals, risks to the organizations, should be on a corporate risk register under the being monitored by the board with proper board oversight to make sure that appropriate controls are in place to bring risk down to an acceptable level to the organization and to the data subject. So if you just think about some of the risks and you think about them in relation to the data protection principles, risks to data subjects where data itself is inaccurate or out of date could mean that the data about somebody's social security benefits are being sent to the house that they lived in 2 years ago, as a result of which somebody who shouldn't know what social security benefits they're getting is aware of it. Having an inaccurate email address might mean that you send detail about somebody's illness to another person who shouldn't be seeing it. Data kept for too long means that there is a risk to the data subject. That data could be accessed and stolen, and they don't know how long you've held the data, you don't know how long you've got it, but it can still be stolen and they can find themselves dealing with a identity theft crisis, drawing on data that goes back 5, 6, 7 years. Holding data that's accessible or irrelevant means, again, if there is a compromise of the systems, an attacker gets hold of that data, it means that data that you didn't really need for your purpose, but is really useful to the attacker, is now in the hands of somebody who can use it to damage the people who trusted you with the data. Disclosure to the wrong people, this ranges from using the blind carbon copy but in an email incorrectly, using the carbon copy but incorrectly. It happens time and time again that organizations don't train their staff on how to use CC and BCC properly, and therefore emails go out to tens, hundreds or thousands of people, which enable everybody else on the list to know who else on the list has exactly the health or political or religious or gender issues that the email is about. That's a major breach of trust because it's been disclosed to a lot of the wrong people. Insecure transmission of data can lead to it being compromised. The point about encryption of data in flight is important because compromising transmitted or stored data can mean a high risk to data subjects. And all of those things mean that data can be used in a way that's unacceptable. Selling an emailing list is a way that data subjects don't necessarily expect you to behave. So lots of ways in which non-compliance can drive issues for people. So you might need to use a DPIA where, as you've seen, we are processing large numbers of special categories of data or monitoring large numbers of people in a public place. For most organizations, the key things are, for instance, where you're consolidating information held by separate databases in different parts of the organization. You're creating a new IT system that's going to collect and process personal data. Those are the kinds of areas you're combining 3 different HR systems, some of which are on spreadsheet, into one new sexy global HR system. You definitely need to have a DPIA system, definitely need to have a DPIA in the early stages of that project, because you're going to be putting together data that wasn't previously held in the same place, You're going to be giving access to that data to a much larger number of people than previously had it. And that throws up new risks that you might not necessarily have considered. So those are the kinds of areas where you might need a DPIA. And having determined that you need a DPIA, you're then going to be thinking about what actions you're going to take to address the risks that you've assessed. The risks are, the actions are things that you might take in sequence. You might have a number of different actions in relation to risk, but overall what you're trying to do is reduce the likelihood and or impact of a given identified risk. And you try to do that at a point when you're designing the system, not afterwards. You don't want to build a system and then go, wow, we just looked at the system and discovered there's some significant issues we've got, so we'll have to bolt on some additional security mechanisms. The DPIA process is saying, actually, you need to have thought that through early on, build it into your processes so that you make the right decisions right the way through the exercise. GDPR in Article 36 says that where there is a high risk to the rights and freedoms of data subjects, so you need to have a mechanism for determining there's a high risk. That goes back to your risk assessment methodology. Where there is a high risk to the rights and freedoms of data subjects, you must talk to the supervisory authority, who in the UK, as you know, is the Information Commissioner. The controller must consult. The way in which the ICO responds should include written advice to the controller on how to do the DPIA. Often this type of information is already published on the website. Might ask for further information about what you're doing. We'll certainly ask for information about the purposes of the data processing and the means of processing it, what measures and safeguards you're putting in place. It's likely that you're going to need a DPO, so the ICO is going to probably ask you for contact details for the DPO, and they'll want to see a copy of the DPIA when it's completed. There may be other information they want, but that's the kind of core minimum that you should expect there to be. So DPIA is not something that you go away and do in a sloppy way on your own. It's a formal exercise. You're going to have to show the ICO. If you're doing it, if it's a mandatory DPIA, which has got a high risk to rights and freedoms. If there's no high risk, yeah, simply a risk, and you're doing a DPIA, you're going to want to keep a record of it because it's part of how you're going to demonstrate that you were not negligent in meeting your obligation to put appropriate measures in place to protect the rights of data. So just linking that into the question of different ways, appropriate measures that you can put in place. Article 32 of GDPR says that adherence to an approved code of conduct, as identified elsewhere, may be used as an element by which to demonstrate compliance with the requirements set out in this article. And the kinds of systems which already exist and which we expect supervisory authorities to recognize start with ISO 27001, ISO IEC 27001, which is the information security management system, which more and more companies around the world are being externally certified as in compliance with. ISO 22301 deals with business continuity, and increasingly BS 10012, which is initially just a British standard, but it's for a personal information management system. It deals very specifically with personal data, and where allied with ISO 27001 gives an organization the core building blocks of a proper privacy compliance framework. Those are measures which, because they allow for external audit and external certification, are a mechanism by which you can demonstrate to any third party that you've taken appropriate steps to protect personal data. You haven't just yourself decided that you're doing a good job. You've got an independent third party to audit you against an international or national standard. That's a very good and effective way of demonstrating to third parties as well as to the ICO that you've got yourselves on top of the requirements. So when thinking about risk management frameworks, you've got those standards. The thinking about the appropriate organizational and technical measures, as I said at the beginning, those terms are not defined inside GDPR, which makes the decision quite difficult. It means that determining what to do without reference to external standards can be dangerous, because what one person's appropriate is not necessarily the next person's, and what you're trying to deal with is an assessment as to whether you've been negligent or not. So deploying a recognized standard is a good way of saying, well, we did the best that we could have done. What GDPR is requiring an organization to do is to assess the appropriate level of security, taking account of the risks that are presented by how the data is processed, looking at both accidental and unlawful destruction, loss, alteration, unauthorized disclosure, or access to personal data, whether in storage or in transmission. So it's a very broad definition of the scope of the application of appropriate technical and organizational measures. And the second bullet is making, again, the point that GDPR is asking you to take account of the risks, and recognizing the risks have different likelihood and severity, different likelihood and impact, that you should put in place appropriate organizations to demonstrate that processing is performed in accordance with the regulation. And appropriate, the reason I said earlier on that it's likely to be subject to court decisions for years to come is what's appropriate for a small organization will not be appropriate for a large organization, and vice versa. An organization with 5 people and 5 laptops can only do a certain amount in terms of protecting data. It can encrypt laptops and use encrypted email and make sure that only named users can access the laptops, and that's probably pushing the edge of what's possible. An organization of 500,000 people, on the other hand, ought to have in place a very comprehensive information security management system with regular external and internal penetration testing, with widespread ongoing training, with internal incident and breach management, and a number of other appropriate measures. So it's got to be appropriate for the organization and appropriate for the risks that the data subject plays. Of course, the data protection officer is going to play a key bridging role between how the corporate risk management approach is handled right now and the broader cybersecurity risk management and personal data risk management is handled. In some parts of the European Union, some sectors of the European Union, of course, GDPR intersects with the new Network and Information Security Directive, which applies very specific cybersecurity requirements to internet platforms and to utilities, to critical national infrastructure. But overall, the key thing for all organizations is, how do I determine what an appropriate level of risk management is without doing a DPIA? And the answer is it's really difficult to do it. So the steps for a DPIA, then, to sum up what I've been saying, is first of all, identify whether or not one is needed. The 4 tests, special categories, 3 tests, special categories of data, change in the way we're processing or monitoring of data subjects on a large scale. What's the information flow? Do a data flow mapping exercise to determine what the current or intended data flows are. What data we're collecting, through which channels, how are we going to share it, who's it going to be shared with, who's going to see the data, under what circumstances, how's it going to be protected, how long do we know. Those are all part of the information flow section of the exercise. Step 3 is to identify the privacy and related risks, for which, of course, you need a risk assessment methodology, and this is going through looking at all of the vulnerabilities in the processing, all of the particular possible external threats, and trying to determine the likelihood and impact, or likelihood and severity, of each of the threat vulnerability combinations that you've identified. Once you put that together, what you've then got is, here are the risks that we need to be dealing with in relation to this particular set of processing. From there, you can start working on what appropriate privacy solutions might be. And the privacy solutions might be changes to the software program, might be changes to authentication mechanisms or to passwording, might be addition of management systems. Got to be appropriate to the level of the risk. So identify and evaluate the privacy solutions. Remember, a DPIA is essentially a paper exercise carried out usually before you do anything, and then you sign off and record the outcome. This is what we've decided, this is the measures we're going to put in place. You get senior management to sign that off and say, yes, that's all appropriate, that meets our requirements, and those requirements then go into the project plan. If you've got a waterfall project plan, it's relatively easy. You're going to stick with them all the way through to completion. If it's an agile project plan, you're going to build them in, and you're going to need to revisit them with each of the 2-week scrums to make sure that you are meeting the DPIA security requirements. When the project's completed and is in business and you've gone over to business as usual, you should then continue monitoring the effectiveness of the decisions that you made. If there are you want to find out whether they were effective, you want to determine, if not, what else you could have done, and you want to feed that back into improvements the process, and also improve the process. That's the one you've done the DPIA on, and also feedback into the DPIA process itself. Is there something we could have done better? The training of those involved could have been better. The documentation we could have improved. The third page, all of those should be going back in. So it's a 7-stage process. It should be intensely practical, and it should involve the key people working in a process. It shouldn't be carried out by IT on its own or compliance on its own. It must involve the staff and the key members of the staff actually working within the process, because those are the people who genuinely know what the data is used for, who may already have in place a number of workarounds of which you're not aware, and it's those workarounds, frankly, that get organizations into trouble. So involve the staff working in the process, and as you move over to implementation, track implementation, and then build that back into what you're doing. There's a number of ways in which IT governance as a company can help organizations with the challenge of DPIAs. We obviously have a DPIA workshop. You can go and spend a whole day not just hearing this overview, but getting involved in practical exercise, learning how to do a DPIA. We do that as an on-site workshop for organizations who want to learn with a team of their people how to do it. We can deploy consultants to come and do DPIAs for you. There are a number, and those are all things you can access by talking to one of our account managers. You can phone us up or email us, and we can arrange for account manager to talk to you about how we can help you do this yourself or do it for you. And all of that's supported by a range of other one-stop services, from gap analysis, data flow audits, data protection officer as a service, a very cost-effective way of meeting, particularly with smaller organizations, your obligations to have a data protection officer. We can help with ISO 27001, with BS 10012 cyber health checks. So there's a whole range of services that we can help organizations deploy to achieve their GDPR compliance objectives, to minimize risk to the rights and freedoms of data subjects. As I said, all of that can be accessed through our business. You can email us at Service Central IT Governance, go to our website. You can talk to any one of our cybersecurity or GDPR compliance account managers, quite a lot of information on social media, and we have this ongoing series of webinars, all of which is freely available. This one is recorded and will be made available to people on it so that you can download it probably in about a week or 10 days or so, but all part of what we're doing to help organizations with their ongoing journey to GDPR compliance. And for most organizations, the journey really has only just begun. And that brings me to the end of what I had prepared to say. So we're left with about 10 or 15 minutes to deal with questions that you might have. And if you remember, if you have questions, the way to deal with them is to put them in the question function in the GoToWebinar question box, and that's in your GoToWebinar panel. And I'm going to pick up any questions that there might be. I'll read the question out and I will answer as best I can. So if you have questions, if you haven't asked them, please do use the question function to ask them, and I'll get to them right now. So the first question is, what about personal data on a mobile? Yes is the answer. GDPR doesn't distinguish between mobile devices or fixed devices. It simply says that certain types of data is within scope of GDPR and certain types of organizations are within scope of GDPR. So if you're a private individual, the data which you have on your mobile phone is you're going to be, if it mattered, the controller, but any data which you gather for purely personal purpose is outside the scope of GDPR. So you don't have to worry about that. But a corporate mobile phone, where you've got, it's a mobile phone owned and operated by the company, it's got data collected, therefore, under the control of the company, all of that data is subject to GDPR. If you have a mobile phone stolen, you have a GDPR breach. If the mobile phone is not encrypted with a proper password, then you've got a breach that you're likely to have to report to the Information Commissioner. If you have a mobile phone which is encrypted with a high quality password and which is basically uncrackable, and even if it is stolen, as long as you internally record the breach, you don't have something which you have to report to the Information Commissioner, because there is what's considered to be no risk to the data subject. I do a privacy impact assessment to assess if personal information is being used for a project. If there's no personal information being used or being obtained for reasons other than normal business, would my DPIA be sufficient, or would I only do a DPIA if personal information is involved? So normally before you even start in on a DPIA, you would ask what we call screening questions. One of them is, does this process involve processing personal data? And from a GDPR point of view, GDPR talks only about personal data, not PI. PI is a commonly used term in the US and in Canada and many other jurisdictions, but from an EU point of view, personal data is the very specifically defined term. So if you're not processing personal data in a process, there is no need to do a DPIA. Think about the requirements. DPIA is mandatory if you're processing large volumes of special categories of personal data, if you're processing if you're monitoring individuals in a public space on a large scale, or if you're combining systems in such a way that you create new risks for individuals' personal data, then you must do DPIA. So if you're not processing personal data, don't even think about doing a DPIA. Do you have an example DPIA or structure of it? I know that there is an example DPIA included in the GDPR toolkit, which is available from all of our web shops. I know there is an example of a DPIA template used in our practitioner masterclasses. I'm not sure where else you can get them, but certainly in those kind of places. So that's the second question also about DPIs. And of course, if you go on our DPIA workshop, then we're going to do both a hypothetical DPIA and you're going to spend some time doing real DPIA using real data from an existing organization. What's our view on encryption at rest? Organized tend to rely on the physical security server room to avoid the performance overhead. Well, the simple answer is that performance overhead is no longer really an issue where most encryption at rest is concerned. You get very, very minimal degradation. Years ago, you get degradation, but it's minimal now. If somebody's able to access a server and the server is not encrypted and it's got personal data on it, you will be, and it's a breach, you will be reporting that breach to the ICO. You have no option. The fact that it's locked in a server room is not going to be enough of a defense. Because you can usually get into data that's on a server in a server room from outside of it electronically. The fact that you've penetration tested your network, not going to be enough. The fact that DBAs can get onto it is a risk that you have to manage in other ways. That might be managed through passwords, through background checks and so on. But if a hacker gets onto a network server, if somebody gets onto a network server illegally from within the network and the server has personal data that's not encrypted, you are going to be reporting that as a data breach. You have no option. So our view is very simple. Encrypt all data at rest and in flight. The service degradation is so minimal as to make the exposure simply not worth taking the risk. Yeah, I take the point about DBAs, but you talk already about two different risks. The first is access externally by an attacker. The second is DBAs. You can apply different types of controls to both of them. DBAs you might manage by insisting that administrator usernames can only be used under certain circumstances. For instance, there are a number of controls you can put in place to manage your risk there. I'm looking at being self-employed, hosting overseas students. Arrangements would be made by email. Will GDPR apply to me, and would it be sufficient to store the information in a cloud? Yes, GDPR will apply to you. The fact that you're doing the business on a self-employed basis doesn't change the fact that you're doing it as a business. The only exemption is data collected in a purely personal capacity. So yes, you do have to comply with GDPR. If you're storing the data in the cloud, you simply need to make sure of two things. The first is that the cloud you're storing it in is within the European Union because of the restrictions in terms of exporting data outside the EU, and you need to make sure that it's stored securely in the cloud. Could we ask third-party suppliers to complete the DPIA up to a certain point, and then we add in bits from our end? Of course you can. How you go about it is up to you. The key thing is that as a data controller, it's your obligation to make sure the DPIA is completed correctly. That means that if you ask the suppliers or anybody in your supply chain to complete it, you want a mechanism for making sure they've done it correctly. You want to maybe audit it. You might want to have somebody sitting in on it, but you need to have a mechanism for ensuring that the DPIA is correct, and that when they tell you there's no risk, there actually is no risk, because under GDPR, it's you, the controller, who's on the hook for a breach anywhere in your supply chain. Does a DPIA stop a project continuing, or can it be business as usual? I would suggest always making a DPIA part of business as usual, so that it's a standard part of creating the standard part of the requirements phase of the project. It's built into the planning phase of an agile project. It's part of the epic creation bit of a DPIA. Your data protection officer is going to want to write a story for the epic which says, I want to know that the personal data of all our data subjects is properly protected in accordance with the GDPR, would be the storyline. And in an agile system, as I said, you'll review the DPIA on an ongoing basis, but yes, it should become part of business as usual. You shouldn't be halting a project to do a DPIA. You should be making sure it's simply done as one of the steps in taking the project forward. We run consumer marketing events. What about photos taken at events? Well, that's quite a complex area, because photos are potentially our personal data. Certainly if the photos are being taken with the intention of publishing them in a way that would enable people to be identified, you should assume that they are personal data. Photographs being taken in a private setting for personal use, again, almost certainly not personal data from a GDPR point of view. And I'm sure there are going to be some court cases which deal specifically with the in-between. On the face of it, taking photographs simply of a crowd, for instance, where you're not using facial recognition software, that shouldn't constitute the collection of personal data. But if you're taking photographs from a corporate point of view, it's something I would suggest talking for a little bit of time to specialist GDPR lawyers about, just to make sure that you get the proper advice. Processing details on tenants or in properties they're maintained, should they do a DPIA? That depends entirely on how you're doing the processing. And I think the likelihood is you might not need to. If, however, you've got 1,000 properties and you're processing all of the data of your tenants and their families through a single system which you use to monitor the status of payments and arrears and all of that kind of thing, then yes, I think you would need to do DPIA in respect of that system. If you're a private landholder, you've got 3 or 4 properties, you keep the data on a spreadsheet, then yes, you're subject to GDPR because you're a business collecting personal data, but you're not within the high volumes of special categories of data or monitoring on a large scale or making decisions on an automated basis. So there's no mandated reason to do a DPIA. Toolkit is quite in depth in comparison to the ICO Word template. Scaled number of staff I've asked to complete it. Yes, we understand that. Our experience of DPIAs is that while you can do a relatively simple one at a simple high level that might satisfy the ICO, the reality is that to get value out of it, you need to do a greater level. And our concern with the ICO's template is that even though they publish it, it's not necessarily going to give you the depth of protection. And frankly, until we see a court case where the ICO's template is held to be perfectly adequate, because it's in many of these areas courts are going to make decisions, not supervisory authorities. We're slightly loath to use a simplified approach to doing DPIAs. Example of a high risk that should be discussed with the ICO was not so much the risk that you have to discuss, it's the processing which creates high risks for data subjects that has to be discussed. So If, for instance, you are going to, in an organization, let's pretend you've got 5,000 employees, you process health and safety data through a system which is managed by the facilities people, you process HR data through the HR system, you process health data through a separate health team, and you decide to pull that all together into a single HR system that enables you to link up all of that information about different individuals, and which means that people in each of those teams will access a single system. You are creating, obviously, new and high risks for all of the data subjects, because suddenly people in facilities will be able to potentially access information about the health circumstances of people working for the organization. So that's going to create high risks for data subjects. So you would consult the ICO about that type of a processing. Yes, you can write into a contract that the data processor or the person in your supply chain will guarantee that the DPIA is correct, but that won't absolve you from your obligation as the controller to ensure that data is properly protected. It will certainly give you a basis for a claim against a processor if there is a breach. So the kind of circumstance that you could imagine playing out is one where your processor has a major data breach. They tell you about it, you're the controller, you report it to the ICO, you're complying with everything, and it turns out that the processor, when they said to you they'd done the DPIA properly and put the proper controls in, had failed to do so. The controller will talk to you, the ICO will talk to you, you're the controller, and say, actually, it was your responsibility to make sure this was done. We're going to find you. And that's who they'll find. They won't find the data processor, they'll find the controller. You're now in a position where, because you've got a proper contract, you've made sure it's enforceable, you can then lay that off against the processor and sue them for the damages you suffered as a result of their fraudulent claims that they'd done something they shouldn't do. But there is no way you can pass off an action by the supervisory authority against you, the controller, against the processor. So the obligations on controllers are very onerous, and many organizations, we suspect, haven't properly got their heads around quite what it means when the ICO says, yes, it's the controller that we go after. A DPIA, how long does it take to perform, really does depend on the complexity of the process. The answer is it's anywhere between 1 and 5 days typically. We've got because part of the exercise is mapping the data, the second part of the exercise is the data protection impact assessment. If you already got a data flow map, doing the DPIA can be quite quick. If you haven't got a data flow map, it can take you quite a long time to do the DPIA. If you've got an existing risk assessment methodology, it can be quick. If you don't, it isn't. So it depends very much on the preconditions. A well-organized organization with most of the infrastructure, DPIAs can be quite quick. Typically, we expect to do a DPIA for our own processes internally in between 1 and 4 hours. In most of our clients, we expect it'll take between 1 and 3 days because we're deploying people who know what they're doing. We're using tools which are designed to make it easy and repeatable. Often, if you're doing it for the first time on your own, it might take between 3 and 5 days. But I am talking about a reasonably complex process, something like an HR joiners and leavers process that's dealing with, say, hundreds and hundreds and hundreds of people, and there are multiple people accessing it. If you've never done a DPIA, is it worth doing, or simply do it in future? I would say it's not just worth doing, it's necessary to be done. If you currently have processes which fall within the range of processes where a DPIA is mandated, the fact that you haven't done one will be a breach of the law. So go and do one. Don't wait until you have a breach. Go and do one now. Don't just wait until you start a new process, because what you're doing is you're running processes which the law says you must do a DPIA for, and you haven't done one. It's as simple as that. 25th of May, it doesn't say in GDPR, everything you do after this has to comply. It says on the 25th of May, everything you are doing has to be compliant. Sensitivity of employee photos, like everyone has an Outlook, SharePoint. Hey, the simple way to deal with that is to lay the onus on staff and say, it's up to you if you wish to share this data. We are You are the data controller in respect of that specific data. This is how you remove it. This is how you vary it. We are a processor of that data insofar as we're going to provide hosting and security of it. But beyond that, it's entirely up to you. And that's how I would deal with staff posting their photos. They're up to, it's up to them to decide on their own risks. Partially, you can decide on what high volume is, yes. The challenge with high volume is that it is contextual. And again, we're going to have to see what types of court cases are made. But let me give you two examples. If you're processing the data of members of parliament in the UK, there are only 650 of them. And if you're processing the data of 600 of them, I'm prepared to bet that counts as high volume, because that's the very close to the highest possible volume you can have of that group of people. If, however, you're processing the data of 1 million mortgage applicants, and there are 600 MPs amongst them, those 600 MPs wouldn't count as high volume. But the 1 million or 100,000 mortgage applicants, the fact that you're processing that data and you're making automated decisions about it would mean that it's caught by the first and possibly the second of the requirements around GDPR. So it's contextual, but it is common sense. The guidance which has been issued by Working Party 29 is basically that it's common sense. It has the added line that where that processing, this high volume processing is part of the, it's common sense, it's high volume. So it's generally going to be when there are thousands or millions of records, and that's because when there is a breach, it's going to affect large numbers of people. But you just want to be thinking about it from a practical point of view. Yes, 1,000 staff and 23,000 students, I would call that high volume unquestionably. New occupational health system handling 1,000 staff details, I would definitely say that's a DPIA, that's a high volume of staff. You're processing special category of data on an occupational health system. You definitely need to do a DPIA. I would say that that processing poses high risks to the rights and freedoms of data subjects. I would suggest that you should have a data protection officer. You might be the DPO. You should be talking to the ICO. And just for those of you who suddenly go, gosh, I need a DPO, we don't have one, do talk to IT governance. We do have a data protection officer as a service. We do have a law company who can provide very focused GRC, GDPR related legal advice. There are no statutory requirements to do retrospective DPIAs. No, it doesn't say that you have to do them retrospectively. It just simply says in the law that you have to have done a DPIA for processing which meets a particular type of data. And it's true, usually laws are not retrospective. The point about a transition period was that by the time we got to the 25th of May, you should have done everything that would enable you to be compliant on the 25th of May. The same reason as if you've got a large database, there's no requirement to go back in time to retrospectively have a lawful basis for processing personal data historically, but on the 25th of May, you have to have a lawful basis for processing data. Same thing applies to DPIAs. And ladies and gentlemen, I'm afraid we've run out of time for this webinar. I hope you found that a useful hour. As I said, there is quite a lot of free information on our website, lots of ways in which we can help you tackle DPIAs in the form of workshops, training, consultancy tools, lots of ways we can help you tackle GDPR compliance in general, both in the short term and in the long term. Please do come on to our website, and there will be more webinars coming up. If you go on to the /webinars bit of our website, you'll be able to see what those are. Please do take advantage of them. Thank you all for being here. Hope it's been very helpful. Good afternoon.